Hello, I'm Bud Verfali. I'm president and founder of Victory Fiduciary Consulting.
Hi, I'm Ashley Rosser. I'm the Director of Plan Servicing and also a principal with Victory Fiduciary Consulting.
The purpose of this video is to alert 401k plan trustees and plan managers about recent disturbing developments in 401k regulations and court rulings. If you're an owner, manager, or upper-level executive, you're probably going to be considered a plan trustee. Typically, successful owners and managers know how to grow and manage their business. Regarding your 401k plan, you know what you don't know what you don't know, or its implications. Within the next 6 minutes, you will be able to determine whether your company's retirement plan is in the compliance danger zone, whether your existing advisory firm can protect you, and learn what the solutions are.
First, let's start with the Supreme Court case of LaRue versus DeWolff back in February 2008. This landmark case set the precedence where plan trustees' personal assets are now exposed due to plan mismanagement and deficiencies. Attorneys know this, and they're targeting you, the small to mid-sized business owner and the mid to upper income American. There's no more corporate veil of protection. This has certainly changed the entire 401k landscape.
It only takes one individual representing others leading into a class action lawsuit. Imagine just one disgruntled employee who is dissatisfied with the company's 401k plan could individually wreak havoc on a company's solvency, your personal assets, such as your home, perhaps a second home, cars, or even funds set aside for retirement could be subject to lawsuits. Currently, there are over 40 class action lawsuits regarding plan fees in 401k plans. This is alarming. The Department of Labor has recently released benchmarking disclosures to plan trustees. Now, plan trustees must be able to document plan costs every 3 years. High plan costs have been a major contributor in determining why over 50% of pre-retirement households are now at risk of not being able to maintain their current standard of living at retirement.
Now, you may be thinking this doesn't apply to you because you've already hired an advisory firm. Unfortunately, most advisors are generalists. They lack the specialized knowledge on plan compliance and implementation. Your current plan advisor may even be a close friend. Maybe they're managing your personal assets or even the assets of a board member. The Department of Labor states that no matter what, you must always do what's in the best interest of your participants. Plan trustees, just like you, may one day be asked to defend their choice of advisor for their current 401k plan. If your advisor has not already spoken to you about these issues, they probably do not have the specialized knowledge or experience necessary to advise and, most importantly, protect you. There are only 2 reasons why your current plan would have deficiencies. First, your current advisor is simply unaware of these deficiencies. Or second, he or she is aware of them but has chosen not to make the necessary corrections. Quite frankly, I'm not sure which one is worse. You simply don't know what you don't know. Often, the 401k plan trustee is simply unaware of these facts. That's exactly why we made this video for you.
Plan trustees typically rely upon their plan vendors for plan management. Usually, the company's plan administration firm does a pretty good job of compliance consulting, but only as it relates to the record-keeping services, not overall plan compliance. Please note, if your service provider is an insurance company or brokerage firm, they actually increase your liability exposure by protecting themselves at the expense of you. Plans with over 100 employees will hire an auditing firm, but they only audit the plan's numbers, not if the plan is in compliance. By now, you may know you have problems, but let's talk about the solutions. The Center for Fiduciary Studies is the global authority on plan compliance. They have identified 22 best practice standards, fully supported by the American Institute of Certified Public Accountants, ERISA, regulations, case law, and regulatory opinion letters. If a plan can document that they have fully implemented these best practice standards, then they would have taken significant strides in meeting their compliance responsibilities. Let me ask you a question. Have you implemented these standards?
Victory Fiduciary Consulting is a 401k compliance consulting firm that assures our plans are utilizing the best practice standards. We have created a self-assessment of the 10 most common deficiencies that we find in plans. These 10 questions will provide a plan trustee the necessary insight to determine if their plan is meeting basic compliance standards. We call it the employer report card. You may call it a second opinion.
I can only stress, based upon my years of experience working with plan trustees, the critical importance of a second opinion. Whether we may wind up working together or not, hopefully this information has motivated you to determine whether your company's plan is in the compliance danger zone. We want to help you with all the information you'll need to know in order to provide a secure retirement for hardworking employees and employers. It was a pleasure speaking with you today, and we look forward to serving you soon.
Directly below this video, you will notice a link that says, "Am I in the compliance danger zone?" All you have to do is click the link. Once you do, a new box will appear. Simply enter your first and last name and a valid email address. Once you fill this out, we will send you the employer report card. We will also begin sending you critical educational videos that have information that every plan trustee simply must know.